The 7-member court, in its unanimous decision, said that the state will suffer greater hardship if it orders a suspension of the deduction, and it is later found that the law establishing the levy was constitutionally passed. In such a scenario, the court said the Ghana Revenue Authority would be unable to recover the levy. President of the court, Nene Amegache, said the decision was based on 4 benchmarks: the nature of the relief sought, the balance of greater inconvenience and damage, the nature of the legislation which is under attack, including the fact that it was passed by Parliament, and whether the public interest and right of the Ghanaian people is better protected if the application is granted. While the 3 NDC MPs were dissatisfied with the ruling,
for us in the minority, until the substantive matter is determined conclusively, we remain determined that even on the balance of weighing monetary considerations against the weight of a constitutional breach, the emphasis should be on what harm we are doing to the 1992 Constitution and the 3 co-equal organs of state.
The Attorney General says it is welcoming.
Very satisfied and fully content with the outcome today, and I think that for me that underscores the point that do not go to court based on conjectures. I actually heard the court use that expression in relation to one of the contentions of the applicant. Yes, we found before the court a bundle of speculations as to even the numbers based on which Parliament voted to approve E-levy, and I feel that was way below the standard.
Disappointed as the plaintiffs were, Minority Leader Haruna Idrisu tells the media that they take solace in the order to the GRA to keep accurate records of all deductions.
What is refreshing and heartwarming today is the second part of the ruling, which gives directives to the Ghana Revenue Authority to preserve and keep the money. At least some people will not be in a rush to collateralize it until the substantive matter is determined. For us, we raise this matter because it's of public interest significance, it's of constitutional significance, and we think that we will pursue it to its logical conclusion.
But the Attorney General, Godfred Dame, says the order to keep records is already within the normal course of GRA's business.
Clearly, it indicates that there's nothing inhibiting the execution of the law. There's nothing impeding Ghana Revenue Authority from collecting the revenue. And of course, they're also free to apply the revenue to developmental activities to the government. The government is free to apply the revenue, of course, in accordance with the promises that has made to the people of Ghana. And that is all. The only duty is, as the court stated, to keep records. And keeping records is just as they've been doing all the time. So it's just an affirmation or a restatement of their statutory duties. So nothing has changed. The E-levy law is being implemented.
With the injunction dismissed, the Ghana Revenue Authority will go ahead with the E-levy deductions from electronic transfers, even while the Supreme Court hears and determines whether or not the law establishing the levy was passed constitutionally.